that was a result of the CDF Act 203 that was passed by Parliament. And if you remember clearly, there was a history to this. This was a private member's bill that was brought in Parliament when the NAC government came into power in 2002 and starting in January 2003 for their 5-year term. And so a private member of Parliament, a private member's bill was brought in Parliament by a member of Parliament of Kalau. And this act came into force, I think, almost the same year. And the government of the NAC government actually adopted this concept and facilitated and actually supported. And so there's been a back and forth between NGOs that felt that the act as enacted was not constitutional. And so in 2007, there were some amendments to the 2003 Act. So it came into force in 2007, the new Act. And then there was still need or reason enough to have it improved. And with the coming of the new constitution in 2010, a new act was also brought into force, actually an improvement of CDF Act 2007. And so in 2013, preceding the elections, which happened in 2013, in the March of 2013, there was already a waiting act of Parliament, which had been passed by the 11th Parliament, that they were readying themselves for the new dispensation, the new constitution. And so the Act of Parliament was passed. And I just want to show you, this is what the Act, the 2013 CDF Act is actually worded. You see it is written here, an Act of Parliament to replace the CDF Act of 2007. So it's actually replacing the CDF Act of 2007. And so we want to look at the judgment, and I'm going to discuss this judgment in 3 parts, or maybe 3 or 4 parts, beginning today, where we are going to see the background based on the judgment. And then thereafter, we will see how the appeals were done and now where we are, so that we answer that question conclusively on whether there is any future on the CDF. So, and I want to say at the onset that CDF is one of the most impactful funds in Kenya. We have so many funds in Kenya, but CDF is one that touches on all constituencies and actually is being felt across the country. And so what did the Supreme Court say in their judgment that they had recently? And what is the background of this case? And so we have a 30-page judgment ruling. And you see this judgment that came on in 2022 was actually, because we have the trial court, and then it went to High Court, it went to Court of Appeal, and then now it went to the Supreme Court. So it has been a long, long journey since 2013 that has seen us come to this far. And so this case was taken to court by 2 NGOs. We have Institute for Social Accountability, and as the first appellant, and we had the Center for Enhancing Democracy and Good Governance being the second appellant. As you are going to see as we do the background, you'll realize that there was a reason why there was that back and forth. Then the cases were merged, they were consolidated, and up to where we are. And so you see, we have, as you can see, we have the respondents who are listed. There were actually 6 respondents that were listed there. We have the National Assembly, the Senate, Attorney General, Constituency Development Fund Board. We have the Commission for Implementation of the Constitution and Katiba Institute. Those were some of the respondents. And so we see that we are going to see the background of what brought us this far. And so you can see that there was, I want to move a bit so that we see, there was the background to this. We see the background is that the genesis of this matter can be traced to the introduction of the Constituency Development Fund, CDF, in 2003, as you can see here, and which provided that the government was to set aside 2.5% of the current ordinary revenue and channel it to CDF fund to be utilized at the constituency level. In 2007, the CDF Act 2003 was amended. I've already shown you how it was amended and actually replaced to establish the CDF fund, the National CDF Board at the constituency level to replace the National Committee. Okay. The CDF committees were also established with the respective member of parliament being constituency committee patrons. And already from that background, you see that MPs were involved. They became patrons of those committees. On 14th January, the CDF Act 2013 was enacted, and in doing so, replaced the CDF Act 2007. Actually, this is the one I was saying. You see that it was enacted, and it replaced the CDF Act 2007. The one I've read for you here, and we have seen an Act of Parliament to replace the Constitution, and then the Constituency Development Fund Act 2007. And so we clearly see that there was, we have already seen actually on that point that there was 2003, there was 2007, then 2013, which repealed and replaced the 2007 Act. And we also see that it gave members of parliament a role within the CDF Act. So what we see more? Aggrieved by the enactment of the CDF Act 2003, we see that this is what we are seeing. 2 petitions were filed at the High Court. The first appellant filed the petition in Nairobi. That's the Institute for Social Accountability. And then the second appellant, filed the case in Nakuru. You see the case number. Both petitions challenge the constitutionality of the CDF Act. You see the constitutionality of the CDF Act 2013. And then on May 15th, 2013, the consent of the parties, the 2 appellants petitions were transferred to Nairobi on May 22nd, and the 2 petitions were consolidated. So they were consolidated. On 1st October 2013, during the pendency of the case. Now, pendency of the case simply means during the time when the case was not yet determined, the case was still pending. The CDF Amendment Act number 36 of 2013 was enacted. And so you see, there was kind of trying to improve the act. So there was number 36 of the act. There was an amendment to the act. The appellants, with the leave of the court, the High Court, amended their consolidated petition to also challenge the CDF Amendment Act. So they were allowed to amend further their petition to also include the amendment, because it was like what they were challenging in court was like a moving target. So the CDF Act, Amendment Act of 2013 and the CDF Act 2013 are here after collectively referred to as CDF Act 2013. So despite the amendment, for purposes of this judgment, they are called as CDF Act 2013. So at the High Court, 4 issues were identified for determinations. We are seeing 4 issues were identified for determination. One was whether the process leading to the enactment of CDF Act was constitutional, the process. Then number 2 was whether the CDF Act 2013 offended the constitutional principle of public finance and division of revenue. Remember, this is being challenged because there was a feeling that this fund was supposed to be maybe taken to the county and so forth. So the public finance and division of revenue as provided in the Constitution. Then the other issue was whether the CDF Act violated the division of functions between the 2 levels of government, probably the county and the national government, with the view that the MPs who are in the national government were still again doing functions of the county. Then whether the CDF Act offended the principles of separation of powers, where the MPs are involved, yet they also do the oversight. So how will they oversight you when they oversight the fund when they are also involved? And so those were the issues that were narrowed down to after consolidation. And then we have the trial court via a judgment delivered on 20th February 2015, determined that the CDF Act was unconstitutional. And so the first thing they found out was that the CDF Act 2013 was unconstitutional. You can see here, the act was unconstitutional. And as a result, granted the following orders. Okay, so they granted the following orders. 1, a declaration that the CDF Act was unconstitutional and therefore invalid. That was the first order. Number 2, that the order of invalidity above was suspended for a period of 12 months. So the invalidity was suspended for a period of 12 months from the date of the judgment. Remember, this is 2015 now, and the case had been lodged in court way back in 2013. And so in 2015, the court has given another 12 months to allow for, to suspend the invalidity, okay? And so then we find that the national government, in that period, the national government could remedy the defect within the period of suspension, and the CDF Act 2013 would stand invalidated at the expiry of 12 months, or could be earlier repealed, whichever comes first. So you find that what we are seeing here is that there is concurrence that the CDF Act is invalid, and its invalidity is being said to be suspended. It is invalid but suspended, so that to allow the national government to make amendments to remedy the situation. And now, as we are going to see, what did the national government do in between? And just to say it straight away is that they went ahead and enacted the national government CDF Act 2015, which tried to remedy the situation, correcting some of the areas that have been found to be unconstitutional. One being that the members of parliament were involved. And you'll find that, as we can see from here, for instance, we can see a member of parliament You find that, like, for instance, this is the first one. Within 40 days of being sworn in, each member of parliament, particular constituency, shall convene open public meetings with registered voters in each of the elective. It tells you that they have the roles. Shall be an ex-official of the committee. Yeah. The chairperson of the Constituency Development Fund Committee in consultation with the member of parliament. And so you find the member of parliament was so much involved in this. And then let me show you another one. For example, county. You find county appears there many, many times. So, but I want to show you what is the county doing here. For instance, you want to see the county project committee. You see, so it was clear that this fund was meant for the county. Yeah, because now the county is being talked about, yet this money is being handled by the constituency. So there was that contradiction. So you see the county project committee, the county project committee. County project committee means the committee established under section 36. You find the county government under this article, you see. So it was clearly unconstitutional. You find there was a lot of contradiction in the sense that the county, like here you see the county administrator of the constituency. So there was a mix-up between the role of the county in this fund and the role of the national government in this fund. So those are some of the glaring inconsistencies that were there. Then number 7, the next order was that each party would bear its own costs. Now, on the question of whether, now those are orders, but now these are the details, which I will review very shortly. And then we will be able to have gone through the background in terms of what did the appellants take to court? What were the grievances? On the question of whether the constitutionally prescribed process was adhered to during the enactment of the CDF Act, the trial court held that the CDF Act was passed without involvement of the Senate, and that concurrence of the speakers of both houses of the parliament, that a bill concerns county government or not, is neither conclusive nor decisive as to whether the legislation affects county government. The trial court also found that there was public participation through a task force and review panels set up, entirely public engagement. So it is saying that there was public engagement in one sense, that there was a public participation through a task force, and of course appreciates that at that time when this bill was being prepared, the Senate was not there. Okay, so there was a reason to believe that it was not constitutional. The constitutionality of the process was in doubt. On whether Section 4 of the CDF Amendment Act 2013 offended the constitutional principles of the public finance and division of revenue, the trial court established that the CDF was not a conditional grant to the county governments within the meaning of Article 202, Sub-Article 2, and that Article 202 set out structures for equitable sharing of the national government revenue between the national and county governments. The court further found that the national government so desired, that if the national government so desired, it could at its discretion grant additional revenue, whether conditionally or unconditionally, through the county government. But such grants must respect the structures established under the Constitution. So it says there was nothing wrong with that, money being sent to the county, and therefore there was nothing really wrong with money going into the county as long as the structures were respected. Now, on whether the CDF Act 2013 violated the division of functions between the county and the national government, the court found that inasmuch as the national government is to infiltrate the policies at the county, it must do so through structures recognized, and those that do not run parallel to them. The court also noted that charging the CDF with implementing local development under Section 22 of the CDF Act upset the division of functions between the two levels of government. So there was Section 22, which let us see what it says. 22, just want to see Section 22, projects to the community, projects to be community-based. And so when you go to that section, 22 subsection 1, projects under this act shall be community-based. And so what the judgment is saying is that when you look at that section, it upsets the division of functions between the two levels of the community. Because when you look at it entirely, you find that I think both the county and the constituencies have a role. So you see that the court noted that there ought to be a clarity in terms of the role of the national government and the role of the county government. And then finally, otherwise it would upset the division of functions between the two levels. Then finally, on whether the CDF Act offended the principle of separation of powers, the court determined that by involving the members of parliament in the planning, approval, this is very key, in the planning, approval, the involvement of the member of parliament in the planning, approval, and implementation of the CDF projects, the CDF Act had violated the doctrine of separation of powers and undermined the national values and principle of governance enshrined in several articles of the Constitution, including devolution of power, accountability, and governance. And so that is the background, and those are the grievances that were taken to court and how the High Court made a determination. One, they made a determination that this court was, the CDF Act was unconstitutional. And having said that, they also said that the invalidity, the unconstitutionality of the act be set aside, be suspended for a period of 12 months to allow the national government to find an amicable solution or to kind of work some remedy. And after that, then the CDF Act 2013 would be rendered invalid. And so as we speak now, even before this judgment, and based on that judgment alone, the CDF Act that 2013 was now done away with. But of course, you see from point number 11, then the other party agreed with the judgment of the High Court. The first respondent went to court. The first respondent filed a civil case number 92, while the fourth respondent filed a civil case number 97, and they have their grounds. And so we are going to see that in our next video, so that we see how they also raised their grievances and how they were able to raise their grievances and be able to try to convince the court, and how the court later determined and said that and came up with a ruling. And so I want to say